Law 578, Law of Evidence 2. The topic is Documentary Evidence, Lecture 3. Assalamualaikum warahmatullahi wabarakatuh. In this video, I'm going to explain to you the law relating to electronic or computer printout documents or electronic evidence. We have to bear in mind that in the current world of today, we can capture incidents of, for example, bullying by using your handphone. So if you capture the image of bullying and the matter goes to court, can you produce your handphone which capture the incidents of bullying or not? Definitely you can. And the law which allow you to tender this particular handphone or your particular handphone which capture the image of bullying basically is the law under the Evidence Act, that is a documentary evidence under electronic or computer printout document. And to be able to explain to you how you can tender this kind of evidence in the court, we have to basically understand what are electronics or computer printout evidence. Now the meaning of document, of course, we have explained that under section 3 when we discussed about the meaning of document. And when we talk about computer evidence, section 3 also gives you the interpretation that defines computer to mean any device for recording, storing, processing, retrieving, or producing any information or other matter, or for performing any one or more of those functions by whatever name or description such device is called. And where two or more computers carry out any one or more of those functions in combination or in succession or otherwise howsoever conjointly, they shall be treated as a single computer. So basically section 3 defines the meaning of computer. And when you talk about computer have some kind of functions. So it has some kind of data processing device which have perform basically storage functions which include maybe data storage facility. You can also have communication facility, right? And it can operate either on its own or it can operate in combination with other devices. Say for example, if you have a disk, a pen drive, which have certain document in it. So you put it inside a computer and you put it in a printer. So you got a document printed out from your hard disk. So basically all that three devices are regarded as one device, that is computer, and it has storage function. Yeah, it has data storage function. Now when you have your handphone, basically your handphone, you have it has this communication function. So you may receive a call, so this is perhaps Cellcom, so you have the station, the telecommunication station, you have the substation, right? And then your phone. So basically combination of that will be regarded as computer evidence. And handphone itself can also operate in its own way. Say for example, a storage function. You took photo, so it all kept inside the handphone. So your handphone basically perform its role as a computer evidence either in combination of several devices. For example, in telecommunication, it can also have its own data storage function when you take photo, right? Now, when you have this computer evidence, basically section 62 explanation 3 of the Evidence Act explains to you the law relating to computer documentary evidence. Now when you look at section 62, primary evidence means the document itself produced for the inspection of the court. In our previous lecture, we discussed about you tendering an original document. So when you are tendering the original document, you are basically producing a primary document or primary evidence. But concerned with computer evidence, let's look at explanation 3 there. A document produced by a computer is primary evidence. Say for example, just now you have a CCTV which captured the image of a person sneaking into the premises and committing arson. So you want to produce the CCTV and the recording in the court. So basically what you have, the CCTV captured the image and it is stored in a record. Yeah. So you're producing the recording here. So the recording here, if you're producing as a whole document, so what happened here is that you may have the CCTV recording here being played in the court. So the tendering of that will be the tendering of computer evidence, and that kind of computer evidence will be regarded as primary evidence. Or this particular CCTV, you freeze certain part and then you basically printed it and you want to produce it perhaps to show the identity of the person inside the photograph, that is also be regarded as computer evidence. So it becomes computer printout. So you have that. So when you are to tender CCTV, so when you are to tender computer evidence in the court, basically the law says that this is primary evidence. And there are several cases that defines computer evidence to basically reflect computer printout. Say, for example, what you have, you bank into some cash, you bank in your cash into the cash deposit machine. So this is maybe an incident of bribery case. So you got a receipt from your cash deposit machine. The receipt is regarded as computer printout, so it is actually kind of computer evidence. In the case of PP against Ong Cheng Hyong, computer output also is regarded as computer evidence. So it is not a printout, but like the example I gave you just now, the CCTV, you get it displayed, so it could be an output there. So that is also regarded as computer printout. And of course, the case of Ahmad Najib, so you are referring to computer evidence. So when you're dealing with computer evidence here, what kind of evidence will computer evidence be? Yeah, will computer evidence here be direct evidence, or will it be hearsay evidence? Right. A statement in a document generated by a computer may fall under two categories. It may be regarded as real primary evidence. It can also be regarded as a documentary evidence per se, and the content of it may be regarded as hearsay evidence. Now, how will that be so? Right, if you look at the example here. Yeah. So this particular PowerPoint reflects that when you are dealing with computer evidence, your computer evidence can either be real, physical, real primary evidence, or it can either be in the context of purely documentary evidence and the content may be hearsay. Say what happened here is that you have a CCTV which captured the image of the accused person entering the premises, right? And then an arson was committed. So the facts issue here is whether the accused person here committed arson, and you are to tender the evidence of the CCTV here which captured the image of A entering the premises and committed arson. So if you produce the recording, and of course CCTV here falls under the definition of computer evidence. So if you want to produce a recording here, right, you have to ask the question, what is the purpose of you tendering the CCTV, the recording here, what is it for? If you are to tender the evidence here which capture the image of the incident as to how it happened. So basically you produce the CCTV, there is no human mind operating it, it is the computer is processing it and capturing the image. The tendering of the recording here will be akin to tendering of a real primary evidence. So what happened here is that when you are to tender the CCTV, it captured the image, it captured how the offense is committed, so it will be tendering of real evidence. So what happened here, therefore, so this is under section 62, explanation 3, then it becomes primary document. But if say for example, you have, right, you have, the issue here is whether A killed B, right, whether A killed B, so there have been stab wounds, and B's body here is sent to Dr. T, who conduct the post-mortem. Now what happened here is that Dr. T here has to make a report. Yeah, Dr. T here has to make a report upon conducting the post-mortem. So what he did is that he sat in front of a computer, he typed his report and basically got it printed. So he got a printed computer, it's a computer printout evidence. Yeah, it looks like computer printout evidence. But what kind of evidence is Dr. T giving here? Now in this context, so the information inside this particular document, which is a computer printout, basically comes from human mind. That is Dr. T here. Dr. T is the one who conduct the post-mortem on the body of B. So basically the content of this computer document here, the report here, will be what is in the mind of Dr. T. Yeah? So here, if the computer is the document here is to produce as evidence in the court, it becomes, in the absence of Dr. T, that particular document becomes a hearsay document. So it may look like a computer printout, it may look like an output from a computer. However, since the content of it comes from person's mind, you are the one who keying in the data, so basically comes from the person's mind, then this is regarded as original, as ordinary document in which the content of it becomes hearsay, if Dr. T is not called to verify the content, right? So these are example of situation where basically you have recorded statement during investigation, you have perhaps section 112 statement, you have confession made by an accused person before a magistrate was recorded. So, and you have example there, commiss report, medical report, where you have a person here doing an analysis, looking at doing some examination on one particular experiment and write it down in a report. So all that comes from human, and it is only recorded in a computer. So it becomes a computer. It may be a computer printout, but the content of it will be hearsay unless the maker is called to verify the content. So bear in mind that is the position of computer evidence. You got to see whether it falls under the real primary evidence in the context of example just now CCTV, or whether it is only a documentary evidence in which the content is hearsay unless the maker will come to verify it. Okay? Now, so when you are having this one computer evidence, you want to produce it in the court. How can an electronic computer evidence be admissible in the court? So basically, right, if you have a computer evidence here, say just now you have a CCTV, so you have the facts and issue here is whether A committed arson, right? And you have the CCTV here which capture the image of A sneaking into the premises. So you want to, and of course inside the CCTV it is actually recording, it recorded all the incident of the fact that A went into the premises. Now when you are to produce the CCTV here as evidence in the court, you want to get it marked as exhibit in the court. The first question that you have to ask, is the CCTV here relevant or not to your facts in issue? The relevancy is very, very important. It is a prerequisite of Section 5 of the Evidence Act, in which you cannot tender evidence unless it is relevant. So remember, when we discuss relevancy, it may fall under Section 6 to 55 of the Evidence Act. So if you have the CCTV here, capture the image of A here setting up the fire, the CCTV may be tended to reflect how the incident happened, how it begins, and how the fire been made, and eventually cause the destruction of the premises. The CCTV is basically capturing the image of what transpired in a transaction. So the tendering of the CCTV here may be relevant under Section 6 to show same transaction of incident of how A committed arson. If your aim is to produce a CCTV to capture the image of the person, just now what happened here is that you are tendering the CCTV to reflect the incident, how it happened, so it reflects same transaction. If you freeze the CCTV, and then you get it printed, maybe you put some infrared, you use infrared technology so that you can capture who is the person. So the tendering of the CCTV will be relevant, or the CCTV recording or printout will be relevant to reflect the identity of the person who committed the crime. So that will be under Section 9 to show the identity. So it means that if you are to produce a computer evidence, the CCTV or the recording or any printing that comes from the CCTV, number one, it has to be relevant first in the law of evidence. So it can be, so this is the incident, yeah. The second requirement, if you are to produce a CCTV here, is that it has to be within the form that is allowed by the court to tender. So basically, what form does it take? So it has to comply with the nature, the law relating to the tendering of evidence of that form. Remember when we discussed about Section 3, there are three kinds of form of evidence that you tender. You can produce a witness, you can produce a document, you can produce a real physical evidence. For example, here, the murder weapon. So now you have a CCTV here. The CCTV here falls under the definition of documentary evidence, and it is a special definition of computer evidence. So meaning to say that the CCTV or whatever document printed out from the CCTV has to fall within the form of documentary evidence. So it has to fall within the form of documentary evidence. It means that it is a document under Section 3. It falls within the definition of computer evidence under Section 3. And if it is a real, if it captures the image that is ongoing, it becomes a real evidence, then that evidence will be regarded as primary evidence under Section 62, Explanation 3. So this evidence will be primary evidence. However, when you are dealing with computer evidence, there is one more special law that you have to bear in mind and comply with. That is, it has to comply with Section 90A, right? So if you refer to the notes here, basically, when you talk about tendering a computer evidence, number one, it has to be relevant to the facts and issue. And number two is that it falls within the category of documentary evidence, computer evidence, and compliance to Section 90A. Now, Section 90A, basically, the summary of Section 90A is that Section 90A provides you with an exception to the hearsay rule. It means that if you are producing a computer evidence in the court, the CCTV, for example, then the content of it is not regarded as a hearsay evidence if the maker is not called. Because as I told you earlier, the capturing of the image, the image that is captured by the CCTV and recorded, that will be the ongoing incident. It becomes real evidence. Yeah. So it is an exception to the hearsay rule. And the document produced by the computer will, of course, be relevant to the evidence stated therein. And, of course, you have to bear in mind the requirement of Section 90A, capital A, is that someone has to testify as to the good working order of the computer, or certificate is produced in the court that the computer is in good working order. Now, let's look at Section 90A, right? Now, when you talk about Section 90A here, right, Section 90, capital A, admissibility of documents produced by computer and of statements contained therein. 90A, 90, capital A, subsection 1, in any criminal or civil proceeding, a document produced by a computer or a statement contained in such document shall be admissible as evidence of any fact stated therein if the document was produced by the computer in the course of its ordinary use whether or not the person tendering the same is the maker of such document or statement. So if you refer to section 90A, subsection 1 here, the document, the computer document that you produce in the court shall be regarded as admissible in the court if it is done in the ordinary course of its ordinary use. So if the computer here is performing its job in the ordinary course of its use, yeah? And basically, how can you prove ordinary course, in the course of its ordinary use? Basically, there are two ways in which you can establish the ordinary course of its use. Basically, number 1, which is referring to section 90 capital A subsection 2, reading with section 90 capital A subsection 3, it says that for the purpose of this section, it may be proved that a document was produced by a computer in the course of its ordinary use by tendering to the court a certificate signed by a person who either before or after the production of the document by the computer is responsible for the management of the operation of that computer or for the conduct of the activities of which that computer was used. Now, if you look at section 90 capital A subsection 2 here, you find the provision here use the word may be proved. So it means that computer evidence can be admissible by production of certificate. However, certificate is not the only way for you to prove that the computer may be admissible. Alright, so what I mean to say is that, so if you have, right, just now a CCTV, you want to produce the CCTV, right? So this CCTV, of course, falls within the definition of computer evidence. It falls within the definition of a documentary evidence. And the CCTV here is basically a real evidence. Section 62, explanation. Explanation 2, basically this is regarded as primary document. Now what happened here is that if you want to produce a CCTV, the next requirement that you have to fulfill is section 90 capital A. And section 90 capital A is that you've got to prove that the computer here, or the CCTV here is actually working in the course of its ordinary use. So how do you prove that the computer is working in the course of its ordinary use? It can be in two ways. Number 1, by the production of a certificate by a person who is managing the computer, saying that, by signing the certificate, saying that the certificate is actually in good working order and is performing the function in the course of its ordinary use. So you have that. Or under section 90A is where instead of producing a certificate, you call the person who is managing the computer and is able to confirm that the computer is actually in good working order and doing the job in the course of its ordinary use. Right? This is what actually happened in the case of, for example, you have the case of Susilawati. You also have this in the case of Hanafi Mat Hassan. What happened in the case of Hanafi Mat Hassan? If you recall this particular case, you have, remember, the girl, Suzaili, right? She was the software engineer. She went into the bus, right? And she was basically together with another passenger in the bus, and the passenger left the bus and she was alone with the driver. And when she went into the bus, of course, she took a ticket. So she put some money inside a machine in the bus, and basically a ticket is being produced by the machine ticket. And eventually what happened is that she was murdered, she was raped, in the bus, and then she was murdered, and the body was basically dumped at a construction site, right? And the issue now here is whether the accused person here, Hanafi, is the one who was driving the bus, and was the one who raped her. And the evidence that you are concerned here will be the bus ticket. So what happened in the case of Suzaili here, or in the case of Hanafi Mat Hassan here, when you look at the ticket here, of course the ticket here falls within the definition of computer printout. It's a document, of course, section 3, and it's a computer printout. Basically, it's a document produced by a computer. It falls under section 3. So it may be an original, it may be a primary document if you refer to section 62, explanation 2 of the Evidence Act. Now you got to bear in mind it has to comply with section 98. Now what happened in the case of Hanafi Mat Hassan here is that a certificate was not produced by the prosecutor to show that the machine which produced the ticket here, it was in good working order and doing the job that it's supposed to do. That meaning to say that it's doing the job in the course of its ordinary use. But what happened in this case is that the operator of the bus basically gave evidence in the court as to how the machine is working, right? How the machine is working. So basically, there's some information inside the ticket. So the information relate to number 1, the bus number, right? And then it also identify the driver of the bus. It also identify the route it's supposed to take and the time in which the route was taken. The route was taken. So basically what happened in this case is that the witness in this particular case, so you have the witness here who is basically the operator of this bus, gave clear evidence as to how the machine is working, as to how this particular information is produced. Now in this context, the evidence given by the witness here satisfies section 90A without the need for you to without the need for you to produce the certificate, right? And of course, the witness here will have to undergo the process of examination in chief, cross, and re-examination, to reflect that the machine is actually performing its duty in the ordinary course of its business, or its use. The course of its ordinary use, right? So what happened here, right? In the case of Hanafi Mat Hassan, a witness here is giving evidence under section 90A without the need to produce a certificate. Okay? Now, if you produce a certificate, so what happened here is that, so just now the case of Hanafi Mat Hassan, I explained to you the second way in which an evidence under section 90A is given to reflect that the document or the computer is performing its job in the in the course of its ordinary use, in the sense that it is in good working order. However, if you don't produce a person to give evidence in the court as to the manning or the management of that particular computer, right, like the case of Hanafi Mat Hassan just now, or even the case of Susilawati, because Susilawati, basically you have the operator from the telecommunication that give evidence as to how the communication happens, that they can triangulate the fact that they were at the vicinity by the call or the communication that they had. So that will be by a person testifying in the court. If you don't have that particular person testifying in the court, another alternative is by producing a certificate under section 90A. So if a certificate is produced under section 90A, then automatically the presumption under section 90 capital A subsection 4 will be activated, in the sense that, look at section 90 capital A subsection 4, where a certificate is given under subsection 2, it shall be presumed that the computer referred to in the certificate was in good working order and was operating properly in all respects throughout the material part of the period during which the computer was produced, right? So it means that, so once you have a certificate produced by that particular person or authority or company, for example, to say that the machine is in good working order, then it will be presumed to be in good working order. So you're going to be good enough to reflect that the computer is actually in good working order. Say just now, you have a situation, the example I gave you just now, there's a bribery case, you bang into a cash deposit machine at a Petronas station. So you got a cash deposit machine which maybe provides you with the amount and the account number that you have banked into. So you are going to produce this as evidence in the court. Yang Arif, this is the evidence that I actually banked into the account, the accused account. So you are going to produce that you are going to produce that computer printout from the cash deposit machine. That certificate 90A can be produced by the person who is manning the cash deposit machine at the Petronas. So it could be, say for example, you have the Petronas. So say for example what you have here. So you have banked into the cash deposit machine. So it is say at Petronas in section 7 Shah Alam. So who will be responsible for the management of the cash deposit machine at that location? So that particular company will be responsible in producing the cash deposit machine to reflect that the cash deposit machine is in good working order. So it could be maybe the main branch at section 13 will be the one responsible, so the certificate may be produced by them. Or they may have subcontracted it to another person in respect of the manning of that particular document. So we may have a company A responsible in managing the good working order of that cash deposit machine. This particular company will be responsible in producing the computer evidence. All right, the certificate under section 90A. All right, okay. So that will be here. Now, so that will be the first part. Automatically, it's going to be invoked. Presumption will be invoked. Then, if you produce a certificate, basically there's no need for you to call the maker of that particular certificate or the person who produces the certificate, because presumption is actually being invoked, unless you can prove that the presumption cannot be applied by whatever reason, right? So there's no need for you to call the maker to verify the content of that certificate. There's no need because of the presumption of section 90, capital A, subsection 4. Now, the second way of producing to reflect that the computer is actually in the course of its ordinary use is by you calling a person who are responsible in the management of the company. Now, there have been cases that explains as to who are persons not regarded as person under section 90A. You have example in the case of PP against Ong Cheng Hyong. So what happened in this case is that you are calling a supervisor from the JPJ, right? And he says that I'm not responsible, I'm only a supervisor, I don't know how this particular information comes from the JPJ, so he is not a person regarded to be responsible in the management of that computer. So you got to see, whenever you are calling a person who is giving evidence as to the management of and the operation of the computer, that person has to know how it works, because this person will be subjected to examination in chief, cross and re-examination as to the working of that computer. Okay? Now, when you talk about the presumption, so when you look at section 90, capital A, so basically this provision has two presumptions. It has two presumption provision. The one will be under section 90, capital A, subsection 4, in which you have a computer here and you produce a certificate here to reflect that the computer is actually performing its duty in the course of its ordinary use, then automatically section 90A, subsection 4 presumption will be invoked, that the computer is actually in good working order and is operating properly when the document was actually being produced. The second provision on presumption under section 90, capital A is the one under section 90, capital A, subsection 6. This is where the person who is testifying in the court is not the person who is managing, or having responsible in giving evidence relating to the management of the particular computer. So this is a person who may use that particular computer or electronic device, but he is not the person who is manning the computer. Then what happened here is that if that particular person who is giving evidence in the court, he will be giving evidence orally in the court, and presumption under section 90 capital A subsection 6 will be applicable. Yeah, you look at the criteria of section 90 capital A 6 here. It does not have the condition precedent that the document is actually performed or produced in the course of its ordinary use. So it applies to deem the document to be produced by a computer in the course of its ordinary use. Yeah, and this presumption is basically invoked or resorted to when you are having a document here, but the document here, the person who gives evidence here is not the person who is actually manning the computer, but could be the person who used the computer, right? So you cannot invoke section 90 subsection A because he's not the person managing it, but he's the person who basically used it. So that's why you have that example in the case of Hanafi Mat Hassan. The DNA analyzer, you have Ahmad Najib Arif, basically again the DNA analyzer that actually produced this particular evidence in the court. So what is that position? So say for example, you have, remember the case of Ahmad Najib Aris, yeah? So you have an accused, you have facts in issue here, right? Whether an accused person killed the victim, right? And the sample of DNA was taken from the scarf taken from the victim. So you have sample of DNA, right? And then you have sample of DNA also taken from the trousers of the accused person. So the sample of DNA here basically was analyzed by, I put a name here, Mr. T, who analyzed the sample. Mr. T is not the person responsible in the servicing of the DNA analyzer machine. So what happened here is that he is the one who do the analysis. He took the sample from here and here, put inside maybe some kind of a tube, and put inside the machine here. As far as the machine is concerned, he got some kind of report from the machine, yeah, by virtue of that, yeah. So here, he is giving evidence, of course, orally in the court. He is giving evidence of an expert. You have that under section 45, yeah, maybe for the purpose of making an identification of the owner of the DNA. But the information, the kind of evidence that he's producing here is based on the data that he got from the DNA analyzer. So DNA analyzer produced some kind of data. So it's a computer output, computer printout, and this, he is basically giving his evidence based on this data. So in this context, Mr. T here is not the person who is doing the services the machine, yeah. Basically, of course, the machine has to be proven to be routinely serviced. It was in good working order. However, it's not going to be him that is going to produce a certificate because it's not the person who is doing the servicing. So what happened here is that if Mr. T here testify in the court, right, then the presumption under section 90 capital A subsection 3 will be applied, whereby the document here is deemed to be a document produced by the computer in the course of its ordinary use, right? So in this situation, even though Mr. T here is not the person under section 90 capital A subsection 2 or subsection 1 that is manning or managing this particular machine, but he's the one who used it, he can give evidence in the court, and presumption under section 90 capital A subsection 6 will be applied, okay? So that is basically the law relating to computer evidence. Remember, bear in mind, you have to prove, number one, if you are to produce a computer evidence, number one, consider the relevancy of that particular computer printout, or documentary evidence that you want to produce. Number 2, it has to fulfill all the conditions that makes this particular document relevant and admissible. And of course, since this is a documentary evidence, you have to fulfill the requirement of tendering documentary evidence, and since this is a computer printout, Section 90A has to be complied with. Okay, so that is the position on computer evidence. So basically, generally as a wrap, when you talk about documentary evidence, bear in mind the document that you may have can either be a public document within the context of Section 74. It can also be a private document in the context of Section 75. So if the public document that you produce here is a computer printout, automatically Section 90A has to be complied with. If the public document that you produce here is not a computer printout, of course, still it has to be treated specially because it is an exception to the hearsay rule. Of course, CTC can be produced here to show that the document deemed exists. So this is what we study about public document and not computer printout. This will be the law that you have to bear in mind. But the moment it's a public document, it's a computer printout, you have to comply with the 90A. See, for example, accident matter, you want to produce, you went to JPJ and you want to obtain the record of ownership from the JPJ. The JPJ produced a computer printout, so this is a public document, but the nature is in the form of a computer evidence. Automatically 90A has to be complied with, right? So if you are dealing with a private document which is not computer printout, of course the issues relating to whether it was a primary document or secondary document has to be settled first, because originally the law says that you have to produce an original document, and of course it has to be properly stamped, authenticated, and with regards to the content of that private document, then the maker has to come to verify the content. But if you are dealing with a private document which is a computer printout, automatically 90A has to be complied with, right? So computer evidence 90A is going to be automatically applied the moment you have an evidence which falls within the category of computer evidence. All right, with this point, we have completed lecture 3, and the only discussion that we're going to have after this